a lawyer or somebody with a medical professionals with his equipments, etc., would not be able to sort of drive with a light motor vehicle license if you go into the transport category. And the categorization of transport vehicles into heavy and medium category will also have its implications.
That's true.
So it can't be so easily said that because you hold a light motor vehicle license, you would not be able to drive a vehicle which is otherwise also carrying goods.
But you're also right. But that will be a process of testing and then granting a license.
But your notification has stood the test of time also. The central government, although you are saying that it's 141 that you have tried to implement, but over the years it has worked itself out. And look at the large number of people, drivers, who are driving commercial vehicles.
I certainly alive to that.
So you see, look at the livelihood issue.
That's true.
Look at the absolving of responsibility, because if you sort of, I think everybody is taking these aggregate driven cab, etc., riding. Perhaps most of the drivers are of holding anything.
I was given all that data. I looked into it, and it's a very, very important
dimension to be taken.
You have to we can't ignore
the larger picture there.
Certainly. But I think I suppose the rules should be so tuned so that we take care of that also, so that we're not looking backwards. So that is
no, certainly, but these implications, at least in the consideration, not necessarily of the insurance company, but for the country, I think these implications should have a consideration.
Absolutely.
So then, Mr. Attorney, how do we proceed further?
Since the order talks about the two notifications, therefore the Union of India before your lordships.
Otherwise, your view is that Devangan missed critical portions of the statute which were not brought to the attention of the court. Right. And that you would therefore withdraw the notifications and perhaps issue fresh rules or regulations as the case may be.
That's right. Which will certainly address
you will have to amend the act if you have to.
No, that contemplation is also there.
You can't just do it by way of guidelines.
So, suppose section 3, 6, 10 all put together, we look at it and then say, yes, this is how the rules may serve the purpose. But if that cannot be done, well, the act may have to be amended. All that is also the contemplation.
The only way forward is if you feel that Devangan then is to be, either reiterated or overcome. You have to do it legislatively.
No doubt about that. Because when my exchanges of
existing
thoughts was that
position is interpreted by the court.
The government simply issued notifications because the judgment has come.
So your point is that you issued the notification in compliance. It's not in acceptance, but you are bound to comply with the judgment, and therefore you have complied with it.
But the interpretation given of the legislative intent, that still holds the field.
There could be some grey areas where I think
as long as
that's right.
That remains
right. But there is some. But as far as the court's opinion that other endorsement may not be required, maybe slightly on overboard. That statement.
If the existing now Devangan has held the field for a while, right? That has interpreted the provisions of the law. Now, it's always open to the legislature to Parliament, because Devangan is of 2017. It's held the field for 6 years.
That's right.
It is also always open to Parliament to take away the basis of the judgment.
That's open. I mean,
and particularly when the government has implemented it. And why should we withdraw or reconsider the judgment at this stage? And if you are thinking that the judgment is not in line with the statutory position, then if you are willing to amend it as and when you want and change the structure of law. For us to, why should we?
No, that you lot know that process, the thought process already set in motion. But the question is today, what should happen to the notifications and all?
Have you said in your note that the government has set in motion a change in the law or to review the entire position of law? Because this is really this case doesn't raise a constitutional issue; it raises a pure statutory issue.
I understand that, but the question posed to the AG was only how do you look at the notifications, and then the notification to endorse the view taken in the judgment.
No, what we were wondering was that the government can, in the Ministry of Road Transport and Highways and even otherwise, can take a note of whether this interpretation, the consequence of that interpretation is correct or otherwise. If you feel that no, Devangan is wrong and therefore it has to be overruled, you can make suitable amendments to the law to put the matter beyond doubt.
Yeah, that's
A simple amendment to say that, well, if you have a license for this category LMV,
that course of action
you cannot have that license cannot apply with respect to a transport vehicle. A simple amendment will resolve it. But then
the advantage of a prospectivity also. Yeah. Or is there another?
I know that course of action is certainly open to the government, but
that may then also not cause hardship to existing compensation claims which have been submitted.
on that I'm very clear. It should not
Because
any absenting.
all those people who have made compensation claims on the basis of Devangan's
We are very clear on that. I don't think that issue should be reopened at all.
Also, the impact
on
the impact on people. I mean, there may be lakhs of drivers across the country who are today engaged in driving commercial vehicles on the basis of the judgment in Devangan. Now, they will be completely put out of their livelihood, you know. So,
therefore, the
and
government
therefore, this is not just, Mr. Attorney, this is not just a question of interpreting law. It's also a question of the social impact of the law. And you may have to balance a road safety on the one hand with the social purpose of the law. And to what extent would the interpretation in Devangan, that is a matter of policy for the government, to what extent would the interpretation in Devangan in that sense cause a serious impact on the concerns of the government insofar as maintaining road safety? You are developing infrastructure across the country. Will this cause serious hardships in the,
Even the law of insurance.
So, I mean, we can't decide issues of social policy in the constitution bench. We have to go strictly by law. But we are just wondering whether it would be really, in that sense, wise to decide the question of law on a judgment which has held the field now for 6 years. Parliament, the government, and then Parliament can also review what is the actual impact of the implementation of this law. 6 years the law has been implemented.
Yes.
The insurance companies have one angle that, look, we should not be made to pay to take this liability at all. But the government can also take a call on what is the actual impact of the implementation of the law on the ground over the last 6 years. If the consequences are such that it does not pose any grave danger to road safety and protects, the right to livelihood, etc., or you may have some modifications in the future. Give some provision that, well, in the next 5 years or something like that, you must bring your licenses in conformity. You have like a sunset clause. So you may have a variety of options open to you, which we as a court don't have open to us.
True.
There's another